I am delighted by the panel that we've assembled here with the help of the law school and one of our partners in business ethics, Cisco Systems. So I'm joined today by three people who are going to share their insights and perspective around free speech in the workplace. Gary Spitko, who is from our, as I say, from our law school, and I was just talking with him before the panel started about the name of the chair that he holds in the law school because I love it. He's the Presidential Professor of Ethics and the Common Good, and his specialty is in employment law and discrimination, mediation, and arbitration. And next to him is Saidah Grayson Dill, and she is the Senior Director for Employment Law and Employee Relations at Cisco Systems. So she manages these issues and many more in a workplace that 70,000 people participate in. And next to her is Margaret Russell. Margaret is also a professor in our law school. She's also the interim associate vice provost for diversity and inclusion. So we are delighted to have the three of you here. We've had a little bit of time to sort of talk in advance about how we'll approach today's conversation. We're going to start with each of the panelists providing some introductory remarks, and then I'm going to pose a couple of questions to them, and eventually we'll invite you to do the same. So without further ado, I think I'll turn it over to you, Gary.
Thank you, Ann. And I want to thank Sarah Tangdell as well for inviting me to participate. So the panel decided it might be a good idea to begin just by having a skeletal overview of protections for workplace speech. And so I'm going to provide that skeletal overview, and then I think we'll fill in some of the details as the program proceeds. The takeaway, I think, from the summary will be that there is actually very little protection for workplace speech. But when there is protection, it's found in one of four sources. It's found in either the federal constitution or a state constitution. It's found in a statute, it's found in tort, or it's found in contract. Another takeaway is that in general, government employees have more protection than private workforce employees. And that's because the First Amendment doesn't apply to the private workforce unless you can be creative and think of some reason why your private employer is actually engaging in state action as they punish you for your speech, which is a very difficult thing to do. But even with respect to government workers, the protection is quite limited. And the government as employer has much more leeway to punish speech than does the government as sovereign. So there are things that the government can punish its employees for saying that they could never punish a private citizen for saying. When the First Amendment applies, there's an analysis that courts use. It's called the Connick-Pickering analysis, and it generally consists of three parts. And the first part is we simply ask whether the employee's speech is on a matter of public concern. If it's not, the speech is not protected at all. And the theory behind that is that we sort of pre-balance. And when it's not speech that relates to a matter of public concern, the government's interest will outweigh the employee's interest. If it is on a matter of public concern, we ask whether the employee is speaking as a private citizen or is actually speaking in their official capacity. And if they're speaking in their official capacity, again, there's no protection at all for that speech. It's a pre-balancing analysis as well. And then, if it is a worker speaking as a private citizen on a matter of public concern, we engage in a balancing test. And essentially what we do is we balance the speaker's interest in speaking along with the public's interest in hearing that speech against the employer, the government employer's interest in workplace efficiency, essentially. And so there's sort of a sliding scale on each end. If it's speech that is of marginal, if you will, relating to a public concern and very disruptive, it's not going to be protected. Conversely, if it's speech that is of great public concern and not very disruptive, it likely will be protected. With respect to private employees who aren't protected by the First Amendment, the most important source of protection is Section 7 and Section 8 of the NLRA, the National Labor Relations Act. And Section 8 just basically prohibits employers from interfering with Section 7, so I'll just talk about Section 7. And basically Section 7 says that, and again, this only applies to private employers. It doesn't apply to government workers. It also, there are broad categories of private employees that are excluded, like agricultural workers and airline workers. I couldn't tell you why that is, but it is. But basically, Section 7 protects employees, so not supervisors, but employees who engage in concerted action for mutual aid or protection. And in order to qualify for protection for speech under Section 7, you have to have engaged in group activity or have contemplated group activity. So it's okay if you're the first person to speak up, but your goal is to have other people join in the conversation. It has to be about a matter of common concern with respect to your employees. And importantly, it has to relate to the workplace. And if all of those things are true, we then still ask whether the speech has been unreasonably disruptive. And so if it's a very similar analysis to the Connick-Pickering test. In fact, although technically speaking, the First Amendment doesn't apply to any private employees, the analysis that has developed in the First Amendment context is often sort of transported into a number of contract claims or NLRA claims or anti-retaliation claims in the private workplace context. Additional sources of protection, statutory protection for workers include anti-retaliation provisions in a number of statutes. Margaret's going to talk about Title VII, and in a number of accommodation statutes, so like the FMLA, for example. And then also whistleblower statutes are an important source of protection for speech. Then with respect to tort law is rarely successfully used to protect worker speech. But the one area where it has actually been fairly useful is the tort of wrongful termination in violation of public policy. And so there are, like, just to give the most prominent example, the seminal case, a private employee who testified truthfully before a committee of the California legislature and was fired for that testimony, was successful in bringing a claim that that was a wrongful firing in violation of public policy. And then there's contract. And contract isn't typically relevant for most private employees, but people who are covered by a collective bargaining agreement often have a just cause provision in that collective bargaining agreement. Academics, I'm happy to say, have a just cause provision in their contracts. And often high-level executives have just cause provisions. And so the question becomes whether the speech qualifies as just cause to terminate the worker. It so happens that the higher level the worker, the more likely the speech is to be judged disruptive. And so oddly enough, lower level workers who have a just cause provision would have more leeway to have disruptive speech than higher level workers. So that is my brief skeletal overview of workplace protection for speech.
Before we go to Saidah, I just want to make sure we have a lingo opportunity. So if there were terms that Gary or any of the other panelists use that you're not familiar with, I heard FMLA, which is the Family Medical Leave Act, pre-balancing, which I don't think I could explain if somebody made me, but I don't know if anybody else is feeling that way. But if there are any other terms that have been used that people would like clarified, we can do that now.
I can do 7 seconds on pre-balancing.
Thank you. Okay.
Yeah, so the Connick-Pickering test is a balancing test. We weigh the government's interest in the efficient workplace and the employee's interest in, and the public's interest in hearing the employee's speech. This just got louder, I don't know why. The notion is that when the speech does not relate to a matter of public concern, the public's interest in hearing it, the speaker's interest in speaking it, is always going to lose in the balancing. So we pre-balance, and we say that it is never protected. And when the employee is speaking in their official capacity, again, it's a pre-balancing. The notion is that the government has certain interests, the interest of not having the public confuse this worker and this worker's position with their own position, for example. And the worker, to be clear, still has the right to leave work, go and speak on CNN with respect to the very same issue, not in their official capacity. And so the public still has a right to hear that government speaker who will often have the most knowledge about a particular issue. But if they're speaking in their role as, that wasn't 7 seconds, was it? They're speaking in their role as their official capacity, the pre-balancing says they're always going to lose, and so we don't balance anymore. That's the theory.
It was riveting, even if it was beyond 7 seconds. Go ahead, Saidah.
Hi, good afternoon, everyone. Again, thank you to Ann and Sarah for inviting me here today to talk a little bit about the corporate perspective when we talk about free speech in the workplace. I'm going to broaden the topic a little bit to how over the last, I would say, 3 to 4 years, we've seen a more influx of how social justice issues have infiltrated the workplace, and how that does lead to kind of what you can say within the workplace and what you can't say in the workplace. So over the last, I would say, 2 years or so, we've seen a lot of lines being blurred. I would say maybe 15 to 20 years ago, you would come to work, you would have kind of your work persona, you would go home, you would have your home persona. As we've progressed, especially in the Valley, we've worked to knock down walls, and I want to say physical walls and virtual walls as well. Physical walls in terms of you go from many people sitting in offices, I'm talking about very corporate, Silicon Valley. People sitting in offices, people sitting in open workspace. You have the advent of social media to where you're listening to what your colleagues say, not only at work, but also when they're in their free time, and if you opt to become Facebook friends with them or friends on Twitter with them. And as various issues in the media reach a fever pitch, you might hear their opinions on those particular issues. You also see CEOs in the Valley taking a more prominent stand on social justice issues. And the questions that companies have to ask themselves, I think, as this goes forward, is who speaks on behalf of the company, and what does it mean to speak on behalf of the company on an issue of social justice? And what does it mean for the employees who are within the company who feel that, one, they agree and they feel supported by the stance that the company has taken? And by stances, it can mean things that you see in North Carolina, such as HB2, or the quote-unquote bathrooms bill. It could be taking a stand on amicus briefs with respect to gay marriage. It could be with respect to equal pay within the workforce. It could be on policies related to diversity and inclusion, right? When you have your CEO espousing a position and you say, I'm not necessarily sure I agree with that, that kind of affects how you interact within the workplace. Do you feel comfortable voicing something differently from that person or from that company, or from even your manager with whom you may be friends with on Facebook, or even a coworker that you need to work closely with, but you just saw this weekend on Facebook, he or she may have posted, I'm anti this or I'm pro that. How does that affect the workplace? And how do, as we continue to create community within the workplace through employee resource organizations or employee resource groups, a lot of workplaces are talking about teams. So you're talking about people coming together in the workplace and really creating community. And what does that community mean in terms of your interactions? So as we go on, I'll talk about a few scenarios in terms of how Cisco has addressed issues of social importance, social justice, and how we've handling kind of differing views within the workplace. I'll stop there. A little teaser.
That sounds fascinating. I can't wait to get to that. So, no, I want to hear how it's done in the real world. The academics talk about things in a slightly different way. And so I was saying to Gary Spitko before this panel that it's been wonderful actually to participate in the planning, because it's gotten me to think about current day events, real workplace issues, the NFL, Google, things that we're going to talk about later. My own particular role at this point in the panel is just to give a brief overview, or to put into play the piece that has to do with restrictions of freedom of speech, or in some cases, restrictions of freedom of speech in the workplace to protect diversity and respect in the workplace, and restrictions of freedom of speech that may actually constitute discrimination. A lot of people like to think that there is no freedom of speech in the workplace. And as a lifelong ACLUer and somebody who's still involved on the board, it's always very difficult for me to say the words, there is no freedom of speech. So the way that I like to think about it, which I think is very appropriate in explaining what's at stake in in the workplace and in encouraging a culture of respect is to say that as human beings, we have the right to freedom of speech, right? That is freedom of expression. It's a very important right. And so regardless of viewpoint, I really would never take the stance that someone does not have the right to think what they're thinking and say it. What's different, as Gary mentioned, are the legal protections in the workplace, which because of what the workplace is and what other values are involved in the diversity of people and perspectives, really have to put into play restrictions on what is otherwise a human right to freedom of expression. So what I want to talk about in a few minutes is the role of anti-discrimination law, which could be both state and federal. The primary federal anti-discrimination law is called Title VII of the Civil Rights Act of 1964. There are also statutes that deal with, for example, the Americans with Disabilities Act, or the Age Discrimination in Employment Act, or the Equal Pay Act. All of those are statutes in some way that provide legal protections against discrimination. Title VII actually covers race, color, ethnicity, gender, religion. I think yeah, that's it, all right? And in the original act in 1964, it was fewer categories. The famous story about how gender got to be in was that it really wasn't vetted and intentionally meant to be a source of protection, but it was actually thought that maybe if it were thrown into the text of the statute, enough of the members of Congress, congressmen, would have voted the law down because gender was included. But that didn't happen, and so gender was included in all those other categories. Now, I think a way of thinking about Title VII in terms of expression in the workplace is that Title VII it really presumes that there should be protection against categorical discrimination. And given the fact that we don't have any kind of workplace, public or private, and this statute applies to private as well as public workplaces, given that we don't have any workplace in which we basically say, everybody come to work and don't say anything at all to anybody, ever. And don't go online and say anything. Given that we don't have that kind of workplace, how are we going to encourage the norms of respect and civility? Well, an important, and indeed the Supreme Court has said a compelling reason is to eliminate discrimination, right? So let me give you an example of an area of law that's developed in a way that clearly affects speech in the workplace, but it is very well recognized as being an actionable form of discrimination. And that is the area of harassment law. Sexual harassment, racial harassment, religious harassment in the workplace, that can be actionable even if it is only speech, quote unquote, only words. The standard is that it cannot just apply to sort of a one-off, one misstep, one set of comments, although many workplaces have in a structure to try to stop that kind of beginning of harassment right before it gets worse. But the standard is that it would be repeated, severe, and pervasive. And the legal reporters are really filled with cases, thousands of cases, in which people have successfully vindicated their rights. They were discriminated against because something was said to them in the workplace, not just by the employer, not just by the manager, although that could be the source of a lawsuit, but by another worker. And the employer failed to ensure a workplace that was free from that kind of discrimination. So in sexual harassment law, that really developed both in terms of severe and pervasive language, kidding, harassment, teasing, flirting, a lot of the things that we're talking about in the news now. Also so-called quid pro quo, workplace harassment, which is, go out to dinner with me or sleep with me and that'll be your best way to get a promotion. Hello, Harvey Weinstein. And also in terms of racial harassment, there have been just some very egregious instances, not just off-color jokes, but nooses in the workplace. There are actually cases that involve, pictures of people being lynched and people and nooses in the workplace. And so the idea of restricting speech is really to restrict what is obviously a right, not a constitutional right in the workplace, but a human right to having your opinion, by saying there is really a very important reason in the workplace to restrict that. You are at work not to say things that will undermine the effectiveness of the workplace, and that's what discrimination has been found to be. So that's an example of speech actually being restricted, quote unquote, to the chagrin of many in the workplace in order to accomplish a very important societal end and legal end, which is the end of discrimination in employment. There are also examples of speech in the workplace, restriction of speech in the workplace that could be discrimination. And so you may wonder, well, what could that be about? One would be an example of a retaliation, an anti-retaliation provision in Title VII and other statutes. The anti-retaliation provisions exist so that employers can't punish people for speaking out in furtherance of their protected rights. So if somebody files a grievance, if somebody files an EEOC claim, the employer can't punish them. They can't say, you're punished because you took the action of speaking out in that way. That's different really from a whistleblower provision, which has more to do with, and there are different levels of protection for somebody who says, I'm going to blow the whistle because what the employer is doing is against the law, right? Anti-retaliation is, I'm being retaliated against for claiming my rights under the law. Another example, which I think doesn't easily occur to people, but I see you already had a discussion that had to do with microaggressions and really fortifying workplace respect, is to think about the ways in which I think we, perhaps all of us, tend to have blinders on about our own experience as being sort of more central than others. And in the workplace, that can be very subtle. So for example, an example of, let's say you have a hypothetical workplace, in a hypothetical year, less enlightened than now, we hope, and less in a less enlightened area of the country, in which someone complains that a coworker just goes on and on about, their gay, your gay family, your gay, your gay son, your gay marriage, or whatever else. And so they frame it in a way to the employer that makes the employer think, oh, this is inappropriate for the workplace. Well, it turns out, upon investigation, that the employee in question who's being complained about is talking about his or her same-sex spouse as much as everybody else who's heterosexual in the workplace talks about their family, right? So there is a tendency, I think, in a diverse workplace to think that either we all have to sort of bleach ourselves of any kind of individuality, or we all have to sort of walk around each other on tenterhooks and complain when other people seem different from us. And I think the objective, in not just in terms of the law of anti-discrimination, but the position of an employer, right, in figuring out how do I treat people equally, is to be really vigilant, right, and say, if I get a complaint about an employee for saying something inappropriate in the workplace, is that really what's going on? If somebody complains that, the person in the next cubicle has a big religious medal on, and should the employer have a rule that says no religious medals, but not have a rule that says no jewelry? Those are the kinds of subtleties that I think are very important to keep in mind.
Well, thank you all. Those were great remarks to get us started. And Margaret, you've already referenced a few of the examples that we're going to talk about, and just the comments that you were making here towards the end of your opening remarks really lay the foundation for considering the first recent case in Silicon Valley that we're going to explore, which is an employee who wrote a memo at Google that expressed a certain perspective on workplace diversity and certain programs at Google, and was ultimately dismissed from the company. So, Gary, you want to get us started in thinking about that particular case?
Sure. There are, I guess, two sides to, two ways to look at it. The argument for protection would be that it actually meets all of the criteria for Section 7 and the NLRA, the National Labor Relations Act, in that although he was speaking individually, he was communicating to his coworkers, and he said later that his goal was to get others to join in his opposition to Google's diversity efforts. And so this was group action. It certainly concerned the workplace in that his concern was that Google was making, I guess, too strenuous an effort to increase the number of women in the workplace. And so arguably, it may qualify for protection. The thing we always have to ask, is it unduly disruptive? And my understanding is he was a relatively low-level worker. I mean, if he were a supervisor, he wouldn't be covered by Section 7. And so that's an argument against finding it unduly disruptive, but it does go to a core interest of the company. My understanding, again, is that around 20% of their engineers are women, and this is of great concern. And arguably, one can make an argument as well that it contributes to a hostile environment for women. So there's that argument that it's protected. There's also an argument that it's protected under Title VII. And so Title VII protects people from discrimination on the basis of sex. And that's whether you're a woman or a man. And his complaint seems to be that as a man at Google, I'm having a harder time advancing than a woman. That's a complaint about sex discrimination. And the notion is that he was retaliated for speaking. So there are two types of retaliation protection: participation when you file a claim with the EEOC, and opposition. And opposition can be something like sending a memo saying, I oppose this illegal behavior. And the test is whether the employee had good faith, meaning he actually believed it, and reasonable belief that the behavior he was complaining of was actually prohibited by Title VII. Again, I think there's an argument to be made that that speech is maybe protected. So, Margaret, you may have a...
Now, he did not say that he thought the action was illegal, right? The diversity thing. I just want to make sure.
I don't know, but you don't need to label it that way.
Okay.
Right?
Because, it is interesting. So as I said, I'm usually ACLU, freedom of speech. This is how I interpret what happened with the Google memo. So someone who has divergent points of view, which many people do, many people in Silicon Valley especially, engages in a means of communication and to an audience that does provide the employer with the explanation that they're really subverting the goals of the workplace. Right? Some people have said, well, suppose instead of gender, if you were citing statistics and studies about race, would that make it clearer? I think to many people it would. But this is an example of how I think there's almost this false discussion that sometimes takes place about anti-PC workplaces. So, Google says we have this code of conduct and we want to promote diversity, and we have actual statistics about, the numbers of women and how that's an inhibiting factor. So all of those I would consider to be, or they could be argued to be, either legitimate, non-discriminatory reasons for their policy. Under Title VII, they would say this is a legitimate non-discriminatory reason, or they could even argue that it's compelling, that they have a compelling reason of maintaining a workforce in which the dialogue is actually structured toward encouraging diversity. Some would say, well, that's just political correctness run amok. If it were in the academy, I would say that's true. If it were in another setting, I would say that's true. In a workplace, I don't think there are the same legal protections, even though people should feel free to think what they want. I don't think there are the same legal protections, and that the balancing that should take place should take into account the seriousness of what Google is trying to establish, right? And the consequences if they did nothing.
Something you just said also prompted me to think of an implied contract claim that Google has created a culture, and part of the culture they've created is the notion that people have the right to speak their minds about controversial issues. And so while you may not have any express just cause protection, one can make an argument, and California was one of the first states to recognize the implied contract in the workplace. that there's an implied contract at Google that you can speak your mind about controversial issues and we won't terminate you on that basis. So I actually think there are good arguments on both sides, and Google may have just decided it's worth whatever cost we have to pay because our environment is more important to us. But there are arguments to be made on both sides.
Yeah, and I would say practically from an employer perspective, without coming down on whether they were right or wrong in terms of how they address the issue, is that one of the things that I'd be thinking through is, okay, this person put this memo out here citing statistics about women, how they're more likely to do this, and they're less likely to be in leadership positions because of X, Y, and Z. So I think about this person within the work environment, and if 20% of their engineers or technical talent are women, it's inevitable that they're going to be on a team, that he's going to be on a team with women. And if you think about kind of performance management and performance feedback, you have to think as a woman on that team, how would you feel about how he views you given the statistics and the studies that were cited? And you would also think about trajectory within the company. If he was, assuming that he's a non-manager, what would any company thinking about if I had to promote this person to a management position, knowing that they have cited these studies about women, and assuming they have a woman on this team, what does that mean for that woman and her comfort level with her particular manager? So those are some of the things I think practically kind of companies have to gnaw on when they're faced with these types of situations. And a lot of companies really have an emphasis on inclusion, right? So Margaret, to your point in terms of kind of this false dichotomy between PC gone wrong and being able to espouse whatever you want. Many companies in the Valley are based on innovation, and innovation, you need kind of all ideas to come to the forefront, and that's often the argument for why you want a diverse workforce, but it's also the argument as to why you don't want to squelch speech. I'll just say speech, not necessarily free speech, although I think it's common lore that free speech doesn't mean free of consequences, which I think is what we're saying here in terms of the workplace. So it's an interesting position to be in, and I think it kind of goes back to who is going to be the voice of your company? Where are you going to land? Because we see the personifications of corporations in the tax code. And now as corporations are starting to speak more and more about social justice issues, it's like, who are you? Where do you stand? Are you on the left, right, or center on these particular issues? And sometimes you do make the uncomfortable decisions because you're called to do so, either because you have an employee population that's very vocal, and they're encouraging you, they're pushing you to do that. And at least in the Valley, where talent is really hard to come by and everyone wants the top talent, a lot of top talent is really pushing their companies to come out on various positions. So there is a lot there in terms of what causes a company to speak.
Does the context that Google is I think right now the issue on the table is being sued by the DOJ to get information about salary equity in the company, and ultimately to be used to determine if there is that. Does that change or illuminate this situation in any way?
I think it speaks to the importance of the issue for the company. And so when you're thinking about was this speech unduly disruptive, the unduly part, the reasonableness part, that's a relevant factor, that this is a company that is struggling to make gains with respect to workplace equality, and now you have someone in the company who is speaking in this way. So I think it's relevant to the balancing analysis, if you will. Yeah.
I do find it interesting. Now I'm thinking about the legal standard of being disruptive, right? Isn't disruptive a positive, right, in Silicon Valley? Isn't that now, that's a good thing, right? So and on the one hand, you say, we want disruptors, but not that way. Not that kind of disruptive.
And that's an important point, that across Title VII and all these statutes, the courts engage in an analysis, and there's lots and lots of case law that says speech that is disruptive, or even, I want to protest X, And so I'm just not going to attend faculty meetings anymore.
Mhm.
Well, you can't do it that way. You
Right.
can't shirk your responsibilities. You can't you can't be overly disrespectful, if you will. There are Title VII cases that speak of a faculty, an administrative assistant who went around to her boss and went to the board, and the Fourth Circuit said that's not protected, to complain about sex discrimination because in pay, unequal pay, that was unduly disruptive and that you sandbagged your boss. It was sort of at the meeting where she showed up to say, I want to complain about something and it's how my boss is paying me. So we do consider the nature of the speech and how disruptive it is and whether it's protected across these.
So is it unduly disruptive to take a knee during the national anthem if you're a football player in the NFL?
Well, I mean, I think the predicate question is where is the source of protection for that? And I've heard really interesting arguments about, it's obvious this is a private employer, yet there have been 2 professors who've written blogs arguing this is protected by the First Amendment because President Trump has spoken out and urged the NFL owners to take action, and so that somehow makes what the NFL, if they were to punish the players, that would make it state action. I think that's a pretty weak argument for state action. With respect to the NLRA, a collective bargaining agreement trumps Section 7 rights. So if the union and the worker get together, the workers get together and say, you know, these things are allowed, these things are not allowed, if that's in the collective bargaining agreement, then you can't even bring a Section 7 claim. At the same time, if the collective bargaining agreement has a standard for just cause, we have to ask whether firing someone because they took a knee is just cause. And I haven't read the collective bargaining agreement, so I don't know. I have this vague notion that there's something out there about behavior that sort of undermines the perception of the NFL. I'm sure that's not the language. But if the collective bargaining agreement addressed this, then that would actually control over the statutes. I've heard arguments that this is actually Title VII protected, that the objection to these players taking a knee is that they are stepping out of racial place. And so to be disciplined for stepping out of racial place is itself a violation of Title VII. So there are interesting arguments that can be made.
Yeah, I mean, when I hear about taking the knee and the NFL owners versus the players, I think about what could have happened or what steps could the NFL or a particular team could have taken in the beginning such that it wouldn't have reached a controversial pitch the way it is right now, but both sides felt like they have been heard. And I think back to some of the things that we've implemented at Cisco. One, we have a social justice committee that was born out of a few things, born out of Cisco stance on HB2 in North Carolina, Cisco and seeing what was going on in the media and in the world related to the extrajudicial killings of blacks by police and other things that have been happening and how that comes in the workplace and understanding how people have difficult times having those conversations, but because you're bringing your whole self into the workplace, how that profoundly affects your ability to do your job. If you want employees at their best, how do you create the space for them to speak about what's concerning them outside of the workplace, in the workplace, so that they can concentrate kind of on the job at hand? So one of the things that we've done is when it came to HB2 in North Carolina, so Cisco, our headquarters are here in San Jose, but our second largest site is in North Carolina. So you have a little bit, I mean, just stereotypically, 2 divergent kind of frames of mind in terms of social issues. If you just take, South versus, the left coast over here. And,
Can you just explain what the bill is about?
Sure. So HB2 in North Carolina was the bathrooms bill. Charlotte, the city of Charlotte in North Carolina had passed an ordinance where you couldn't discriminate against transgender individuals. And one of those aspects was they could use kind of whatever bathroom that they wanted to, either the bathroom that was their, that was equal to what they were assigned to at birth, the gender they were assigned to at birth, or how they were living their life now. And in response, the legislature in North Carolina passed a bill saying, one, you can't pass no local city or locality could pass a law that was protective of transgender rights. And then secondly, everyone had to use the bathroom that corresponded to their sex at birth. So a lot of people said, okay, that's North Carolina. I get it, but then I don't get it, right? And the I don't get it, the concern came from from a corporate perspective is one, we have employees in North Carolina. We have employees that travel to North Carolina from everywhere. And when it came to our employees saying, I am nervous about my physical being going into North Carolina, because if I physically appear to be a woman, however the sex that I was assigned to at birth was male, and I go into the men's room, I'm nervous about what's going to happen to me in that circumstance. So therefore, it's going to affect me in the workplace. Like, I'm not traveling to North Carolina because, I fear for my physical safety. And as a result, you heard this, and then there was a groundswell from various businesses who either plan to put operations in North Carolina or are already there to say, okay, we're going to sign a letter from the business community to the governor, to the state legislator to say, we are against this and we need you to fix it in order for us to continue to do business in North Carolina. You also have, for companies with established operations in North Carolina, they have their employee populations. It's like, does this mean that you're not going to invest in me, that I'm in North Carolina because you've come up against this bill? And how does a corporation balance that? One, in terms of social justice, this is the stand that we're taking, and also taking care of the employees who are in North Carolina and not saying, well, it does not mean that we are abandoning you out there. So lots of conversation in the workplace. And I think, when you become a manager, no one really tells you how to have these really difficult conversations that are so deeply personal. It just doesn't happen. So we as a company decided, like, how do we give our managers kind of a little bit of background so that they can enter into these conversations in a respectful manner, or such that their employees feel like they can come to them and say, I'm feeling uncomfortable and this is why, and give managers an opportunity to say, okay, here's someone you can talk to, or you can talk to me. And some of our employees were like, Cisco, why are you even, what does it have to do with you selling routers and switches and us being technology? Like, this is a North Carolina issue. It has nothing to do with us as a company. So what we did is we had a town hall meeting in North Carolina where we provided a little perspective in terms of why the company decided to take a stance. And if you were against that stance, you have the ability to express yourself, and how it goes back to your original question about the NFL. I feel that if corporations or if business entities give their employees time and space to talk about issues of social justice that is important to them at their core, I think you have more of a bit of a win-win situation. Another example of that is after all the disruption we saw in Charlotte in terms of the white supremacist march, et cetera, that was another thing that happened, and people in the workplace are talking about it, and they're like, company, where do you stand on this? Our CEO had tweeted about it, other executives had tweeted things about it, but the question from the employee population is, well, where do you stand? So one of the things we did, we said, okay, we'll create a social justice fund. Here are some organizations that you can give to, and Cisco has a matching program. So therefore, if you feel strongly about it, here's a way that the company is supporting you, and you have ability to really put your money where your mouth is.
You made just passing reference there, but I'm curious to know if customers were part of the equation in the discussion at all, and how they were reflected in these decisions and the exchange that you had with your employees.
Yes, I think that is a great question. So, I mean, obviously, people want corporations to speak on behalf of one item or another in social justice because they feel corporations carry a certain weight, right? But corporations only carry that weight because they have customers kind of supporting them and has built them up to whatever particular stature you're talking about. So on our social justice team, we have, so I represent legal, and we have employee relations, and we have our Office of Inclusion and Collaboration, which is our Inclusion University arm at Cisco. And then we have individuals who, from the sales team, who kind of bring in the customer voice and let us know, okay, if we're to take this stand in North Carolina or Texas, what do we think the consequences of that are? So they bring in that voice, but ultimately, when it comes to moral courage that Leslie was talking about in the session before, is at some point you have to make a call, right? Who are you, and who's making that call as to who you are? And you bring in those voices, and someone makes the call. Your CEO, your management team, et cetera.
Margaret, did you have anything you wanted to add?
I have a lot of thoughts, but I don't want to deny people the chance to ask questions. But let me just say just quickly about the NFL, because that is it's a really interesting example, because it's not your usual job, right? So there's the aspect of the job that has caused people to be concerned about people taking a knee is that it's visible, right? And it communicates to the public. So in a certain sense, I think that, that's kind of the odd situation, right? That the question is not just, as it is with the case of the ESPN commentator who said something and was, I think she was suspended or put on leave for a while. It's what's the role of the public, right? And where do they fall into the equation? And so that really goes two ways, because you have people who say, this has turned football into an entirely different experience. This is where I go to escape, and instead it's become a political statement. And then you have other people who are saying boycott the NFL if they don't allow freedom of speech from their players. I mean, the truth is the old model of the master and the servant, not just black, white, but whites, right? Black, so masters and servants in the labor relationship, it just doesn't fit, right? When we talk about wanting to respect diversity and uniformity and the whole person, right? But, my parents' generation didn't talk about bringing their whole person to work. Forget that. So.
Thank you. Well, thank you very much. This is a great conversation, timely, and I really appreciate your participation, both the panel and the audience. We have